Any objection from the state?
No objection on the court hearing that motion.
The defense?
No.
Okay. I think what I'm going to do is ask Ms. Richmond, who's probably here somewhere, why don't you come on up and have a seat, because you're going to argue the motion. Ms. Richmond, I'd ask you for future references, if you're going to argue motions in court, to not show up in a t-shirt.
I apologize, Your Honor. I did not know that I was going to be arguing on the motion. I don't have anything to add other than what was submitted in the motion.
I may have some questions for you, but I want to, what I've decided to do when I looked over the motion is I want to re-watch the video, because I think it'll be useful for me. It's been about 2 weeks, give or take a day or two, since I've seen this video, and it's really, I think, sums up kind of the events that occurred immediately around the things leading to the charges in this case. So I wanted to watch that again, but only the portions that we saw at the last hearing. And I actually asked State to speak with defense counsel. Is that what's queued up?
I did speak to Attorney Cotton before we went on the record, and we weren't exactly sure what you wanted to for sure see, Judge. We queued it up at about a little over 9 minutes left. Did I approach you on this? It's about at 9 minutes and 39 seconds left. And where it's queued up to start is just before anyone arrives at Mr. Fratello's residence. But that's kind of the essential part of this whole case.
Okay, that's what we'll do then. I mean, the main part is we'll start at this point. Without the objection to that. Okay.
Judge, I do saw there's very the victim too. So we had our personnel. They call them, but you're going to watch.
I also addressed this after the motion time where on social media, and the victims heard the dialogue.
Press dispersed it, but I can't speak to that. The words that were
audio from inside the shots. Statements.
I'm here to address watching this video, and I don't want it to go. It sounds like the pieces that Ms. Richmond is referring to occurred after the gunfire, which makes sense. And that's the end of what I saw last hearing, and that's where I was. Just so counsel is clear, we're coming up on, we can stop it. Okay. Very good. And,
Start the video. It says 43 minutes and 59 seconds into it, 9 minutes and 39 seconds left.
okay.
I will try and stop it as soon as you hear the 2 shots. I'll try and stop it right away to the best of my ability.
Mr. Johnson, I'm going to ask you to stop it right now for a minute. I want to stop it because I want to address the parties. I've allowed the press to come in and video this and stream it. If there's any objection to that, I want to hear about it now. I'll rule on that objection, but I want everybody to understand fully what's going on. And I say that because it was raised by Ms. Richmond. I now know where I'm going to stop it, but having said that, is there any objection to that?
No.
And not from the state? She said no.
I just want to confer with Attorney Richmond. I'm going to have Attorney Richmond check with the family because they don't want it played. I don't want it.
Whatever
At
you
least I'll
said is
check.
fine. It's better for us to let they see, so people can judge by themselves. Yeah.
Your Honor, there's no objection from the family.
Right.
Okay, then I will abide by their decision.
Very good. Then go ahead and continue the.
Turn right, then the destination is on your right.
can recollect, I stopped the video at 49:12. After the second gunshot, because then there was graphic audio after that.
Back to the party, Ms. Richmond. Just go with Mr. Johnson. I guess I'm going to want to hear your suggestion. If you want to lay that out again, and then kind of your rationale, reasoning behind it, so we can make a record.
Okay. Some kind of interruption in the family. They wanted to say so for the trial. I want the court to know that the victim's family, from my meetings with CP, with his family, really loved him. And the primary people I dealt with, his mom and dad and brother, and they're right behind me. Those are the people I dealt with the most. And I think the family is really grieving a loss of that most of us can't even imagine. I met with the family of the victim probably more than any other homicide I've been involved with in 32 years as a prosecutor. The families went through a lot of different emotions when we met with them. The two primary emotions, which I understand, I can try to understand, are sadness and anger. And I try to understand those emotions from their perspective as a prosecutor, but also I'm a father as well. I have 2 daughters. But I don't think anybody, myself or anybody else, can really understand the pain, probably, that the family goes through in losing a loved one in this way. Unless one of us has lost somebody, a child in this manner, or a brother or sister in this manner, you can't really understand. You can try, but you can't really understand it. I wanted to start by talking about the victim a little bit and his family, because we become so focused on legal issues and motion hearings and preparation for trial that I wanted to start with that. Now, I read the motion that Attorney Richards filed on behalf of the family. And I understand my duties as a prosecutor is to seek justice. What is justice? It doesn't tell you in some book or statutes. And I'll tell the court what I've done to the best of my abilities. I use my experience, my common sense, which is important, my moral compass. I prepare, review the facts of the case. I did that in this case. I take input from other prosecutors I worked with. I talk to the detectives, who are the primary detectives on this case, and then I make a decision. I have to do my job to make a decision. This isn't a case about complying with victims' rights. We've done that. It's about the victims don't agree with the proposed resolution. And I understand that. I want to put on the record that each case and each set of facts is always different. And I, as a prosecutor, can try and compare this case to other homicides, but they're in court process. They're never the same. You can try and make a comparison. I spent a significant amount of time reviewing this case. And I'm the one that charged this case. It's my case. I charged it. Put on the record. I think maybe some prosecutors wouldn't charge this because of the self-defense claim in this case, but I charged it. And I asked Deputy D.A. Saunders to be on this case because I recognized from the very beginning when I charged this case, it was going to be a very, very difficult case. And sometimes when I have a case, I'll ask a newer or a less experienced prosecutor to help assist me. I wanted an experienced prosecutor on this one, and that's why I asked WBAY Saunders to assist as well. I wanted the court to know that many times, and the court will probably understand this from when you were not just a judge, but as an attorney as well, many times you don't know every detail that came to the trial. You try and read every little detail, you try and watch all videos, you read every report, and you prepare and you write questions, and that's what Deputy Saunders and myself did the 2 weeks before this. Our primary focus for about 2 weeks was this case. And we did a significant amount of preparation, and I try and go in with this mindset. It doesn't matter that I've been a prosecutor for 32 years. I try and go with the mindset that I don't know everything. And I know I'm a human being, and that my judgment can be different than somebody else. So I learn something new probably every day as well. So I consulted with my fellow co-counsel, Deputy Saunders, and he agrees with what I'm going to be placing on the record today. But because of the significance of this case, I mean, a human being lost his life. I also wanted to staff this case. I wanted to go over the strengths and weaknesses with other prosecutors I worked with. And I did that. I think there were probably 6 prosecutors that Deputy Saunders and myself sat down in the law library with and kind of went over the case. You know, like you were looking at the video and stuff, but we went over a lot more. And after that, I wanted the opinions of the prosecutors I worked with. It was unanimous, all the prosecutors that were there for that meeting, that everybody believed this was going to be a very, very difficult case to obtain a guilty verdict. And I think it's important that the people I'm meeting with are prosecutors that charge cases, that have that mentality, work with the police, work with victims, and they're used to going to trial. All of the people in that room believe that we should really, really try to see if this can be resolved, because there was a big concern about the not guilty verdict. Mr. Cotton is an experienced, very competent defense attorney, and from the very beginning, when we would talk about the case, I think they thought they had a very significant and valid self-defense claim. He recognized, I think, the difficulties the state would face, and I recognized the risks that we would have if we went to trial. And I think, let him speak for himself, and then I think he recognized the risk to the client if there was a trial as well. The trial is such a final, all or nothing event, guilty or not guilty. So myself, but as an office too, we had to decide what should you do based on the facts of this case and the risks involved. I did not want to take a significant risk of having no conviction. I did not want there to be potentially no accountability for what Michael Patella did. I thought that would send the wrong message if a not guilty verdict came back to the defendant, to the people that were involved in this situation, to the community, to the if that happened, if there was a not guilty verdict, and we can't tell for certain, we don't know. I was concerned that even though the family of the victim doesn't agree with what I'm saying, with the recommendation we made, the family, if there's a not guilty verdict, the family of the victim will not be able to tell you about their loved one, have input for sentencing. There would be no justice at all, in the state's opinion, and no accountability. So I realized, Judge, that you don't know all the facts. You only know what you've seen and heard. And sometimes when we have so many motion hearings and things like that, like we did in this case, it gives you a better picture. Because prosecution, we read all of these reports, we watched everything. But you got to read briefs on this case. You got to hear things that we tried to keep out of evidence, and were successful in some of the things were admitted into evidence. And it gave you kind of, I hope, an idea of the complexities of the case. The self-defense claim in this case is real, and it's a strong self-defense claim. I'm not going to go over all of the facts, but I wanted to justify the decision we made in this case from the state's perspective. And in essence, this case comes down to this video, what happened. But there was a little more to the story, and really, Judge, the only thing I would say is there was really essentially kind of two groups of friends. One group of friends was the victim and his friends, and then Mr. Brutala, the defendant, and his group of friends. And there was going to be evidence at trial that the group of friends with the victim, the CPC, there was one of his friends who pulled a gun on Mr. Brutala. You heard about this in the motions. Probably within about less than 2 hours before the shooting, pulled a gun on Mr. Brutala. The person that brandished that gun was in one of those vehicles that you saw on the screen. There were two vehicles that went over to Mr. Brutala's residence where he lived with his mom and his dad. And one vehicle had two people in it. It was a silver Acura. You can see kind of plenty of a parking lot. The other vehicle had three people in it, including our victim in this case. It was in that white Dodge Charger. The person that pulled the gun earlier that day was in that silver vehicle. He's one of the people that got out of that car. So the car, you could see him from the Amazon truck going across the street to where Mr. Brutala's mom and dad lived. The fact that the two cars went over there, the group, I'll call them, including our victim, and there were three people in that white car, two people in a silver car, went over to Mr. Brutala, where Mr. Brutala lived with his parents before the shooting was an important fact that we can't ignore it. Three of the people actually got out of those cars and you saw it and went up to the house where Mr. Brutala lived. And they looked like they walked up the driveway. We're not sure exactly how, but they got out of their cars and went up to that house. Mr. Brutala and his friend David Garza came driving down the street at some point. And it looked like when several people were walking down the driveway. And the testimony I think you would have heard is that Mr. Brutala and Mr. Garza are in this red Jeep. Mr. Brutala was the passenger in that red Jeep. And when they saw the vehicles, they fled, tried to get away. They saw those two cars there. I'm sure they assumed who it was. The information we have is they probably would have known who was the driver, at least, or owned, or usually drove that white vehicle. The normal person that was driving that vehicle, and he ended up being driving this case, was not CPC ever, but another friend. The other part we can't ignore is that Dodge Charger pursues very quickly the vehicle Mr. Brutala was in. That the states would have to contend with one of the arguments at trial that the Dodge Charger itself is a weapon. The vehicle, the car, is a weapon as it pursues at a high rate of speed. And Mr. Brutala, I'm sure, based on what I talked to his attorney about, I think they would argue that they thought they were going to hit that car coming at a high rate of speed. They were scared because they saw that vehicle at their house. They was concerned because one of the people in this group of friends that CPC was part of earlier that day. And Mr. Brutala told law enforcement he saw somebody with a gun in the back seat of that Dodge Charger. And when the gun he saw in the back seat, he said he saw it, he fired twice. 2 shots. There was a shot, and one of the shots killed the victim of this case, CPC. It appears it went through an open driver's side window right in front of where the driver was seated and killed our victim who was in the front passenger seat. Now, we had a trial try and dispute that Mr. Brutala couldn't have seen the gun in the back seat. It happened too quick. I don't know what he would have said at trial, Mr. Brutala. I know he told the police. I don't know if he would have said he saw the rear view mirror, but he said he saw someone with a gun in the back seat of the Charger. The police, right after this happened, this was only about a block and a half, 2 blocks from, it was a street, Clay Street, runs parallel to Webster, right by St. Vincent Hospital. So right after our victim was shot, they went around the corner and got to the hospital immediately. And the police, the silver car ends up at the hospital as well, and a few minutes later after the white Charger. And everybody is there with the victim trying to help him. I told you that Mr. Patasi saw a gun in the back seat. Police arrived, they find a gun. It's in the back seat. We couldn't change the facts of the case. He says where the police found it. Those are just some of the obstacles that the state would have to overcome at trial. Things that's difficult is the burden of proof is on the state. We talked to the victim's family about that. A self-defense claim is and always has been the focal point of this case. And we reviewed and analyzed it over and over again with the self-defense instruction. We had to recognize the state has to prove beyond a reasonable doubt that Mr. Brutala did not lawfully exercise self-defense. We have to prove that. If a jury thinks that Mr. Brutala probably didn't exercise lawful self-defense, they think he probably didn't. That's not good enough. That's to be all 12 beyond reasonable doubt, as the court knows, that he was not exercising lawful self-defense. I don't expect the family of the victim to be able to look at this case objectively, because it's their son, brother, friend, relative who's deceased. I don't know that I could look at it objectively with a relative or my child either. But I have to try and do my job as a prosecutor, and I can look at the case objectively. And I had to look at, and we all had to look at, when we staffed this case, the risk of a not guilty verdict with the facts we have in this case, this situation. And so I thought it was important to not just use my own judgment, but to reach out to staff it, talk to the detectives, do as much input as I could before I made the final decision and asked to potentially resolve this. One thing I want to put on the record, one of the prosecutors I used to work with, he doesn't work in our office anymore. Whenever I would struggle with the decision, in this case too, he would always say, you can't change the facts. The facts are the facts. That's the way they are. In this case, it's kind of unique because I don't think a big difference between the facts viewed by the state and the defense. It's just applying the facts as is, watching the video, trying to slow the video down. Is it lawful self-defense or not? Knowing what we know about the facts that I just put on earlier on the record about a gun being brandished earlier in the case, knowing if there was a gun found there, knowing those facts, is it self-defense or not? If we prove it beyond reasonable doubt, we get all 12 people to agree that it's not lawful self-defense. That was the issue. I can do right now in analyzing this case to at least come up with the best decision I can with this situation. I can't change the facts either. Now, it's the state's position, it's my position on behalf of the state that secondary reckless homicide is appropriate. It's charged right now as first-degree reckless homicide. But the plea agreement is the plea to an amended count 1, secondary reckless homicide, without the use of a gun. That is a Class C felony. Class D, I'm sorry, I said C. Class D felony. It has a maximum potential of a $100,000 fine and imprisonment up to 25 years. Broken down, the maximum is 15 years of initial confinement and 10 years of extended supervision. State agreed to move to dismiss the other 2 counts of recklessly endangering safety by use of a weapon, and about the other 2 people that were in that charge that were endangered. And then the state agreed that the state will ask for a PSI if you allow us to do the plea and then get a conviction. The defense is going to ask the court for a PSI. The defense can argue and ask you to not have a sentencing recommendation in PSI. Sometimes they do that. The state won't object to that. But the state agreed to cap its recommendation at 5 years of initial confinement and 10 years of extended supervision. The defense is free to argue. Now, from the state's perspective, the main thing we're gaining from if we do this is to get a conviction for homicide. worry about what would a jury do. There's no risk of a not guilty verdict. And if the court allows it and we get to sentencing eventually, the family of the victim does not have to agree with this recommendation. They will be able to address you finally. They will be able to say what they think is appropriate within the parameters of the maximum penalty. But we'll have a conviction. They will be able to address you, tell you what they believe is appropriate. And obviously, the court, we allow this to go forward, and we do the plea today. I know you voiced as part of your plea colloquy, you have to go over it. You're not bound by anything the state argues, or the victim's family argues, or the defense argues, or Mr. Patala argues. You will be allowed, as you tell everybody, to do whatever you deem is appropriate based on the facts and all the sentencing factors you have to consider. I think the law in this case is basically you just have the discretion, Judge, to, if you want to reject the plea agreement and not allow a plea for the second-degree reckless homicide, you have to, I guess, believe it's not in the public's interest, and then we'll be scheduled for trial. On behalf of the state, I'm asking the court to allow the amended information to be accepted. I'm asking the court to allow the defendant to enter a plea today to that homicide charge. I'm going to ask the court to schedule a sentencing date after the plea. Then at sentencing, I'm going to ask the court's permission to allow the victim's family to be able to address you, because they'll for certain be able to address you if there's a conviction. There will not be a risk of a not guilty verdict at trial, and the family would be able to for certain address you. I want to thank the court for listening to my reasoning about the state proposal, but I think it was important for me to put a lot on the record, and the main key in this case is the risk, and I want the court to know, I know there's a risk every time I go to trial. I realize that. But after conferring, staffing this case, the state thought it was a significant risk of a not guilty verdict. I didn't want to take that risk of I didn't think that would be justice if there was a significant possibility of a not guilty verdict of nothing happening for taking someone's life. And so that's why I'm asking the court to allow this.
Okay, thank you. Mr. Cotton? I really don't have much to add. I think Mr. Johnson really covered it. We're obviously in agreement with what's been offered. And we relied heavily on that. I agree with Mr. Johnson that it's I think from our perspective, a very good defense case. The exhibit that you just watched today, the compilation video, if you will, I think I said this at the last hearing, but it's somewhat of a remarkable situation, Judge, to have the Amazon truck with the cameras parked literally in front of Mr. Vidal's home with such crystal clear video that demonstrates what took place. And I think the backstory that Mr. Johnson just explained to you is important here. Frankly, Mr. Vidal was doing everything in his power to avoid confrontation on this day, Your Honor. Everything. Everything. And he was the one, and it's been an anguishing experience for the Brutala family throughout this entire proceeding. Yes, their loved one is alive, of course, but he now is going to have a homicide conviction if you allow this to go forward. And justice for the Brutala family would look like a not guilty verdict. That's how they would see it. And I think both sides just see it differently. A judge once told me that the best circumstances are when both sides walk out of court unhappy. I don't know if that's true or not. But I don't know that anybody's particularly happy or thrilled with a homicide conviction. Mickey, Mr. Brutala, did everything he could to avoid confrontation. He heard that these people were going to his mother's house. His parents were gone. His younger brother was home. He went there. He was with Mr. Garza. He was a passenger in the vehicle. He's a lawful gun owner. And he has his firearm with him, which he's allowed to have. He had a gun pulled on him earlier. He's driving away. There happens to be a dash cam in the Dodge Charger, so there's no ambiguity about what happened. He was being pursued at utterly reckless speeds in a residential neighborhood. You saw them run a red light. In fact, Garza ran a red light to try to escape the group. So it is a strong self-defense case. Everybody knows that. And I know you don't read every police report. I agree with Mr. Johnson. The law is basically like he said. Do what you think is right. If you think it's right to reject the deal, you're going to reject it then. But I think to echo what was said, there's risks on both sides. I've been doing this 20 years. I've worked other cases with Mr. Johnson, at least one other case at the trial up here in Green Bay. And in that case, it was a split verdict. The jury found the defendant guilty, but they found the defendant not guilty on the mental disease or defect part of the case. And we've been down that rabbit hole before, where you think you have a good argument in one way or the other, and the jury does something different. And the reality here is, from a defense perspective, yes, it's probably, perhaps highly likely that it would be a not guilty verdict. I agree with the consensus of the DA's office, but that's a risk. That's a risk. He gets convicted of first-degree reckless homicide if that were to happen, and he faces no longer a recommendation of 5 years, which he's relied very, very heavily on in agreeing to take this deal. Thank you.
Your Honor, may I briefly respond to that?
Ms. Richmond, I was going to suggest that to you.
Thank you. The family fully understands, and I should say the family and the other two victims, UCR and BT, they all understand the risks of going to trial, and there could be a not guilty verdict. However, with, for example, the key problem areas that Deputy District Attorney Johnson was just elaborating on, the other two victims, the living two victims, were immediately taken from the hospital to the Green Bay Police Department to be interviewed. I represented both of them prior to this incident, and I guess, let me back up. These two groups of kids have had a history of disputes. They fight, they beat each other up with their hands. They don't shoot at each other. This was the first time there was a gun issue. With the incident that happened at BP a couple hours before this, the family and I have not seen any of the discovery. We first learned a couple of days before the trial was to start of this BP worker, or A&W worker, I'm sorry, that was an independent civilian witness that was apparently going to testify that OT had pulled a gun out on Mr. Putala. The interesting thing there is Mr. Putala's people had videotaped the confrontation between he and OT at the BP and put it on the internet. So I was able to obtain that video a long time ago and gave it to Mr. Johnson. In that video, you see Mr. Putala being the aggressor and going up to OT's vehicle and yelling at him. It's consistently been OT's statement that Mr. Putala was the one that pulled the gun on him and not he pulling the gun on Mr. Putala. Then we have this independent civilian witness, and it was like, okay, that's interesting. This is the first we're hearing of that. What's going on with this? After looking into it very briefly, that independent witness is friends with Mr. Putala and his whole group of friends. It's clear from social media they have all friends in common and on each other's friends list, which is very concerning. And further, this independent witness that claimed that he was standing there, I think maybe having a cigarette or something on his break from E&W, in the video is actually in OT's vehicle in the passenger seat. He was not an independent witness. He called OT to that BP station to come and meet him. It's likely now, looking back on this, that this was a setup for a confrontation between Mr. Putala's group and that independent witness calling OT down there to fight. Because as soon as OT is driving in the parking lot of the BP, it's Mr. Putala coming up aggressively to his window and yelling and motioning. We don't see a gun by Mr. Putala in that video either, I won't make that clear, but it was OT's statement that it was Mr. Putala that pulled the gun on him, not the other way around. The other interesting thing is, in the video, we see the white Charger. I believe last time we were here, it was stopped right when Mr. Putala stuck his arm out the window with the gun. There was clearly at least a car length in between the front bumper of the white Charger and the rear bumper of the red Jeep. It's Mr. Putala's claim that he saw a gun in the back window. When BT and UCR were taken to the Green Bay Police Department, I was with them both when they made their statements in the interrogation rooms, and it was consistent between the parties that where everyone was sitting in the vehicle. BT was in the rear passenger side of the vehicle, which was on the far side from the window where Mr. Putala claims he saw a gun reached out. It was very clear from the different statements from the different people, BT was never on that driver's side to be showing a gun. Further, from that angle, being at least a car length behind, there is no way he would have seen in the back window of that Charger. The family and UCR and BT all understand that there's risks. Juries are unpredictable. I've been doing this for 16 years. We never know what juries are going to do. However, they want their day in court. They understand the risks. They're not absolutely opposed to a plea. The largest factor, the hardest factor for them to get over in this is the amended charge that greatly limits your discretion in sentencing. They don't want an amended information filed reducing the charge. They want the court to be able to decide the appropriate sentence without significant limitation by the plea offer. Thank you.
Judge, can I say one thing? Sure. I'm not going to stay here because I have a court trial, but I do want you to know this too. One more thing. A lot of the arguments that Attorney Richmond made, a lot of those, if we went to trial, I'd be making some of those arguments to the jury. One other difficulty is I want the court to know, remember we had a motion hearing where there was 2 vehicles that pulled up from Mr. Vitale's house. One was a silver vehicle, one was a white vehicle. We were able to keep out to create a trial. That silver vehicle that had 2 people on it, one of them, his initials was OT. Police found a gun in that vehicle. We kept that out, but one of the worries and concerns is if we start as a state trying to argue that Mr. Vitale is not telling the truth, OT, that person, never pulled a gun at the gas station. One of the things that could become relevant then is, well, right after the shooting, OT's in a car. Guess what's in there? A firearm. This is going to be another complicating factor. So, but I agree, we were going to make some of the arguments that Attorney Richmond made if we had a trial. So I want the court to know that it's very complicated and difficult.
Okay, thank you. So, in reviewing the information that has been filed in this case, there's currently 3 charges. First degree reckless homicide, use of a dangerous weapon. It's count 1. Count 2 is first degree recklessly endangering safety, use of a dangerous weapon, and count 3 is first degree recklessly endangering safety, use of a dangerous weapon. Really counts 2 and count 3 are very similar. And in reading Ms. Richmond's brief, it really focuses a lot on the public interest. And, frankly, that's the standard that the court needs to look at. The public has a lot of interests at stake in the criminal calendar of a Wisconsin Circuit Court. They really do. And sometimes I don't think the public realizes all the interests they have at stake every time a circuit court branch in this state comes to order. And that's unfortunate. But I move on. Ms. Richmond cited a case which I found very helpful. It's the State versus Conger case because it discusses a lot of the things that surround what we're doing here today regarding this motion. So I looked up that case and I read it, and I'm going to go through some things. It's going to take me a little bit to lay some of this out, but I think it's important to lay some of it out because I've got to consider some facts and exercise my discretion and reason and understanding not only the facts of the case, but what I'm doing legally. And so I want to make sure that everybody's aware that I understand what my role is. In that court, in the Conger case, the court set out 3 questions that were before it. And they're very similar to the questions that are before me here. The first question was, under what circumstance may a circuit court reject a plea agreement? The second question, what factors may a court consider when it reviews a plea agreement? The third one really isn't relevant, at least not yet. The court called it a corollary to those 2 questions, whether a judge who's rejected a plea agreement has to automatically withdraw from further participation. That was a later considered question. The standard of review, Conger noted that, quote, "This court has not explicitly articulated the appellate standard for reviewing a circuit court's rejection of a plea agreement. However, it's implicit in the court's analysis in State versus Kenyon that the rejection is reviewed as an exercise of discretion." This goes to what I think the parties are suggesting, which is the court has discretion regarding this question that's before me. And when the appellate court reviews a court's exercise of discretion, it indicates that it will review, we will sustain a court's exercise of discretion if the court, first, examined the relevant facts, second, applied a proper standard of law, and third, using a demonstrably reasonable or demonstrably rational process, reached a conclusion that a reasonable judge might reach. That court goes on to note, thus deciding whether to reject a plea agreement is squarely within the court's authority. To hold otherwise would permit an encroachment by the executive branch into the realm that was historically in Wisconsin been that of the judicial branch. So in other words, the prosecutor doesn't just get to tell the court, here is what is going to happen in this case. The court gets to determine whether it's going to accept or reject that plea agreement. Later in the opinion, the court cited that Kenyon case again, and it cited that case quite a bit. It notes that, quote, "In all cases, some finding should be made with respect to the impact of the ruling on the public interest in proper enforcement of its laws and the public interest in allowing the prosecutor sufficient freedom to exercise his legitimate discretion to employ to the best effect his experience and training, and to make the subjective judgment implicit in the broad grant of authority under section 59.47, close quote. Goes on to note that our approach has thus required a circuit court to consider the various elements and then exercise its discretion when evaluating the plea agreement. We therefore hold that the circuit court may, in an appropriate exercise of discretion, reject the plea agreement that it deems not to be in the public's interest. The court then goes on to answer that second question. What factors the court should consider when evaluating a plea? So when I exercise my discretion, what should I think about? And it's interesting, it goes back to that Kenyon case again, and it says, what factors are appropriate for a court to consider in deciding whether to reject a plea agreement? It notes that the Kenyon case didn't really make that issue real clear, but it did cite Kenyon in stating, quote, "It would be impossible to make an exhaustive list of just what to take into account in this regard," close quote. Conger, however, went on to outline some things that, while it's not an exclusive or exhaustive list, it's some things to consider. I'm not going to go over all of them because there are a lot of them. What I want to indicate to the parties is I reviewed all of them, but I'm not going to go over all of them. I am going to go over some of them. Because Kenyon indicates that the circuit court should take into account the public's right to have the crimes actually committed, fairly prosecuted, and to the protection of the rights of third persons. It should also consider the public interest in proper enforcement of its laws and the public interest in allowing the prosecutor sufficient freedom to exercise his legitimate discretion to employ to the best effect his experience and training, and to make the subjective judgment implicit in the broad grant of authority under Wisconsin statute, section 59.47. The public interest in providing a prosecutor freedom to exercise the discretion that his or her position authorizes. It also notes that the court should evaluate, the court's evaluation of the defense attorney's reasoning and recommendations reflect a balancing consideration of the public interest in a fair prosecution. Other factors, whether the defendant has voluntarily and intelligently entered into a plea bargain, whether a factual basis exists for the guilty plea, the general public's perception that crimes should be prosecuted, the interests of victims, the court's ability to dispose of the case in a manner commensurate with the seriousness of the criminal charges, the plea's usefulness in securing a legitimate, important prosecutorial interest. It goes on to note in Conger that, quote, there may be situations in which the public interest might better be served by having a case tried rather than by having it disposed of by means of a guilty plea. The Conger case then moved on from discussing the Kenyon case and went on to a different case. It talked about more factors. This was the Kalal case. In that case, it outlined some of the factors prosecutors may consider when deciding whether to file charges. And after the court in Kalal discussed those factors, it indicated that these charges, these considerations could overlap with determining the public's interest with regard to a plea. So the extent of the harm caused by the offense, the threat posed to the public by the suspect, the ability and the willingness of the victim to participate, the disproportion between the authorized punishment and the particular offense or offender, possible improper motives of the complaint, cooperation of a suspect, the possibility or likelihood of prosecution by another jurisdiction. So those are some of the factors. Then Conger went on to discuss even more factors that are outlined in the American Bar Association standards for criminal justice. And then, I'm not going to go over all of those. After discussing all those different factors that a circuit court can consider, Conger goes on to state, that's our Supreme Court in Conger, we are satisfied that a court's consideration of any of those factors in evaluating the plea agreement could be appropriate depending on the factual circumstances of the case. More or less, I have to consider all the facts and circumstances surrounding the case. I have to consider the interests of everybody, which in a sense, when I consider the interests of everybody, I'm considering the interests of the public. Because all of us are members of the public. So all of us have an interest in what goes on in this case, in this building, and in this community. The proposal in this case is to really ask the court to dismiss and read in counts 2 and 3 of the information. And it's interesting because when I think about a plea, the contrast with a plea is a trial, a jury trial. And I'll just note that oftentimes I hear people, not necessarily in criminal cases, but maybe in criminal cases or other cases, we can't agree, just let the judge decide. And when I hear that, I'm somewhat disheartened, because it's as if judges can give magic decisions on everything, and everything will turn out right. And I know for a fact, for all these people in this courtroom, there's very little that's going to come out of this proceeding that's going to make everything seem all right. There just isn't. People have lost lives. People are going to lose freedom. There's going to be a lot of things happening as a result of this case, and it's going to be dissatisfying to almost everybody in this room, and that's unfortunate. The same could be said of a jury. Well, instead of just saying let the judge decide, just let the jury decide. Those results can be as dissatisfying to everybody in the case as any other result. So I don't have any misperception that our justice system, which I believe actually is the best justice system in the entire world for doing what we do, it is not perfect. It doesn't give perfect answers. It doesn't give perfect solutions. It doesn't make everybody feel good about everything. But it's the best, I believe, that exists in the world for taking care of conflict and crimes in communities. The request that's being made is that I dismiss counts 2 and 3. Frankly, when I consider the public's interest, counts 2 and 3 don't rise to the level of being so significant regarding this fact pattern and the public interest that that's a huge issue. I say that because the more serious charge is count 1. And I'm going to get to that in a minute, but the plea agreement that says those 2 counts, they're not even homicide charges. They're recklessly, first degree recklessly endangering safety by use of a dangerous weapon. I would imagine that if this case concluded after a trial, after a jury trial, where that one of those counts, or both of them, or the counts that a jury convicted on, I would imagine the victim's family would be incredibly disappointed because it would seem insufficient. It would. But those are out there. I speak mostly of that count one because I think in the proposal that I'm being presented with, that's the significant piece. Count one in the currently filed information is for a Class B felony. Class B felony involves imprisonment not to exceed 60 years, but everyone needs to understand that a portion of that is initial confinement and a portion of it is extended supervision. Count D felony, which is what is being proposed, is a fine not to exceed $100,000 or imprisonment not to exceed 25 years or both. Certainly a reduction in the amount of incarceration. I consider that when considering the factors surrounding this case. I do consider the fact that the request is for a homicide charge. It's not like a sort of a battery charge or something, a disorderly conduct charge. You can see a first-degree reckless homicide being amended to various things because it falls within the definition of a lot of different types of crimes. But it's a homicide that's being proposed to me. I also want to indicate that I reviewed the jury instructions for both of the offenses. The one charged, again, I'm speaking of count one. I don't want anybody to think I forgot about count 2 and 3. But I focused on count one because it's the more serious one. So I looked at counts 2 and 3, but I'm going to focus in my discussion here on count one. And I looked at the jury instructions: first-degree reckless homicide, second-degree reckless homicide. The elements of that offense, what the state would have to prove beyond a reasonable doubt, are very similar. There is a third element in first-degree reckless homicide versus second degree. The third element is the circumstances of the defendant's conduct show an utter disregard for human life. The first two elements, again, which are similar in both charges, are the defendant caused the death of the victim, in this case CPC. I want to recognize, I understand that there's been a loss of life, and I'm not just talking in some legalistic vacuum, that there's human beings that are being affected and lives that have been lost, and I understand that. The second element of both are the defendant caused the death by criminally reckless conduct, and then there's a definition which again is very similar in both instructions. The second degree doesn't have this third element. I've read it already. It says the circumstances of the defendant's conduct showed utter disregard for human life. That third element goes on for a definition. It says, in determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The jury would be asked that as well. I will note that I read the jury instruction, reviewed it for self-defense. Both of the parties had submitted in advance their requested jury instructions. There were a couple submitted that there were regarding self-defense. The one that I gave most attention to was instruction 805, self-defense, force intended or likely to cause death or great bodily harm, because we're dealing with a gun. And I focused on that, even though I would have to determine whether those instructions would be given. And there's certain things that have to be demonstrated there. And I looked at all those things because it strikes me that it doesn't take anyone too much to reach the conclusion that this conduct that was occurring in this state was very dangerous. It was very risky for the public as a whole. This community we live in, having this kind of thing go on, is scary. And there's human beings that live around what was going on here. Any of these bullets could have gone into a home. we hear about that on television. We hear about things like this, and somebody in a home who was just sitting there watching television ends up getting shot through a window by accident. We hear about those things. It was very dangerous. And I raise that because the public in this community has an interest in trying to ensure that doesn't happen. High-speed pursuits in our community are dangerous as well. They lead to people being injured. They lead to people being hit. You see those things on television as well, especially in a residential neighborhood. Now, it depends, of course, on what time of day we're dealing with, but it really doesn't matter because families, individuals who have different work schedules, different things going on, are moving about in their neighborhoods with the expectation that they will be able to cross their street or leave their car, go in their home or come out of their home, and they'll be relatively safe, and that there won't be a high-speed pursuit going on. That is a concern to the public, and the public has an interest in ensuring that kind of thing doesn't happen. This self-defense claim is troubling because it causes, when I do this kind of an analysis, thinking about this plea arrangement, it causes me to dwell on the concept of how each party in this case was behaving. And I don't have any desire to start analyzing how someone who's lost their life was behaving in a particular set of circumstances. However, it does certainly bear on whether this plea is appropriate to see what each party was doing. Both vehicles were traveling very fast, and it's difficult to imagine what would have happened if at some point somebody said, we're going to break this off, we're not going to keep going. You could see a lot of different things that might have happened, maybe bad ones, maybe good ones. But one of the kinds of things that go through the jury's minds, I think, I'm not the jury, I don't know what they would decide, I want to make that very clear, but in the context of this, the Conger case tells me I need to consider everything surrounding it. That's why I wanted to review this video again, because it brings to mind a lot of things that need to be considered when someone analyzes, should I go to trial or not? That wasn't in my mind. I was going to trial whether or not anyone here in this room decided to ask me not to. This case would be in front of me and I would hear it. The attorneys have to weigh that, however, in determining the strength of their case and what they proceed with. I've outlined some of the things that are occurring in the public interest from this high-speed event that was occurring on our streets. There was a whole lot of reasons why the public should be interested in that. The public needs to be interested, however, in what our prosecutors do, and how they function, and how they operate in the system. They have discretion to make charges. That's what they're hired for. That's why our state legislature hires prosecutors, puts them in DA's offices around the state, and says, address crime. They have discretion in making charges, and then they have discretion in evaluating your case and decide how to move forward. Pleas are things that happen in our court system all the time. If it weren't for the process of pleas, probably our system would not function as it does very well if every case went to trial. But on the other hand, cases are different. There's more serious cases, there are less serious cases. And the notion that a prosecutor would come forward in any particular case and say, I don't want to take this case to trial on this charge because I'm concerned about it. I will note that Mr. Johnson certainly did hit a chord with me when he described trial prep. I am very familiar with how trial prep works. I trial prep myself in private practice, and you do learn more about a case as it approaches. Why? Because everybody has a workload, and as your workload is way off in the distance, you focus your attention on other things. As your workload comes closer, you focus on that thing, and you learn more because you have to commit things to memory. You have to make evaluations. You have to be prepared to act on your feet so you learn more about a case. and the notion that a prosecutor would arrive at a particular charge and say, this is a risky proposition going to trial, and I'm concerned about the risk that there won't be any accountability to the public moving forward. And the public would not find that in their best interest. The defense piece, there's a public interest in what defense attorneys do. There most certainly is. And sometimes defense attorneys get derided for what they do. They have an obligation under our United States Constitution and under the Constitution of this state. Everyone has a right to a defense. Everyone has a right to a competent defense. Everyone has a right to have an attorney who will zealously advocate for them and be fair and make assessments of the case about whether it's time to charge forward or time to draw back on a particular case, even though certainly the client ultimately makes the decision. The court, there's an interest in having there's a public interest in having a defense bar that behaves in that fashion. And I need to think about all of those interests when I consider whether or not what is being offered to me is in the public interest or not. And I have to say that when I'm presented with this, when I know what I know about the impact of this case, the notion, and I think Mr. Cotton mentioned it, that there's risk all around. There is. There is a great deal of risk on each side of this case. There is a risk on the part of the state that the claim of defense, the self-defense that's being made, could be acceptable to a jury. I need to remind everybody, still pending before me is whether I'm going to let in some of those statements that are made in this vehicle. That decision by me would have a big impact on the risk. Risk is going to shift when I make that decision, and nobody in this room knows what I'm going to do on that issue. But it would alter risk. It really would. The state has a risk in trying this case, that there in the end, the accountability that would exist would be potentially first-degree recklessly endangering safety or nothing. No, they certainly have an upside. An upside is that there would be first-degree reckless homicide. The defense has a risk. They really do. And they don't know what I'm going to rule on this motion to suppress, but the risk they run is that there's a conviction on that first degree. So all of this risk is being assessed by the parties, and the public has an interest, a strong interest in knowing that everybody's doing their job, being vigilant in what they are trying to do in their position. And I can't find that in this case either of the attorneys are somehow misunderstanding what their role in the system is, or incorrectly analyzing their risk or what their duty is. I can't find that this recommendation is contrary to the public interest. I will note that the DA has a right to ask for whatever they want for sentencing, and I don't have to follow it. What is being asked that I do in this case by the parties is have some accountability for a homicide. That's what happened in this case. Have some accountability to the public that if these kinds of things happen in your street, there's going to be some serious ramifications. Have some understanding that anybody involved in one of these cases damn well better investigate their case and understand if they go before the court and make some recommendations, what they're recommending and why they're doing it. Satisfied both attorneys have done that here today. I can't find that this recommendation to me is contrary to the public interest. I can understand why it is dissatisfying to the family of the victim. I get it. I'm not in their place. I can't understand the shoes they're walking in. I can't. But I understand why the desire is to exact the most retribution possible. But I can't find that what I'm hearing today from this recommendation from these parties is contrary to the interest of the public. So I'm going to deny the motion. And I'm prepared to do that?
They're here to come before.
Judge, we filed a proposed amended information, but it's not valid obviously until you accept it. It does amend count 1 to second degree reckless homicide, class D felony, and then counts 2 and 3 were the same. I would move that we should dismiss and read those in. So if you allow the amended information, the defense has a copy in front of them.
Mr. Cotton, you have a copy of that?
Yes, acknowledge.
I'm sorry, Mr. Johnson, I jumped the gun, I interrupted you. Anything else?
Oh, no.
And you said you do have a copy of it and you reviewed it?
I acknowledge receipt, waive reading, and heard not guilty plea.
All right. Then are you prepared to proceed then?
Yes, document 118 is the plea questionnaire, it was filed on April 4th.
Right, so Mr. Patala, the first thing I need to advise you is that you're not a citizen of the United States, plead guilty or no contest for the crimes with which you're charged could result in your deportation, the exclusion from admission to this country for the denial of naturalization under federal law. You understand that?
Understand.
I also need to advise you that if you're convicted of a felony, you lose your right to vote until it's given back to the governor by state law and may not possess a firearm or body armor. Do you understand that?
I understand.
I've been handed this plea form by your attorney. It appears as if you signed this on the back page. I'm going to show you this. I realize this isn't an original, but is that a copy of your signature, sir?
Yeah, I believe so.
Did you sign this document because you wanted to indicate to me that you had reviewed it with your lawyer and you understand it?
Yes.
This form says that you're 24 years old and you graduated from high school. Is that correct?
Correct.
It says you are currently taking some medications. Is there anything about those medications that makes it difficult for you to understand what's happening today?
No.
This form says that you want to give up certain constitutional rights that you have by entering this plea. An example of some of those rights are that you have a right to a jury trial, a right to cross-examine witnesses, a right to subpoena into court any witnesses you wanted to testify for you. You understand that you have all of those rights.
I understand.
And you understand that by entering this plea here today, you'd be giving up all of those rights.
Yes, I understand.
Has anyone made any threats or promises to you to get you to give up your rights here today?
No, Your Honor.
You do need to understand that when it comes time for sentencing, I'm not bound by any plea negotiations or recommendations of lawyers. I'm actually free to sentence you up to the maximum under state law. I understand that.
Yes, I understand.
Did you speak with your lawyer about what those maximum penalties are?
Yes, I did.
Attached to your plea form is a copy of the jury instruction for the offense of second-degree reckless homicide. Is that attached because you wanted to communicate to me that you would discuss the elements of this offense with your lawyer and that you understand them?
Yes.
In order to accept your plea here today, I need to have a factual basis to rely on. So the first question I have for you is, have you had a chance to review the criminal complaint that was filed in this case?
Yes, I have.
And Mr. Cotton, can I use the criminal complaint as a factual basis to take this plea?
Waive, Your Honor.
Okay, Mr. Patel, is that correct? I can use the criminal complaint as a factual basis for this plea?
Yes, Your Honor.
And Mr. Cotton, to read your client's pleas here today are freely, voluntarily, and intelligently made.
Yes.
Then, Mr. Patala, as to the one count of second-degree reckless homicide in the amended information, what is your plea?
Guilty.
Before I do anything further, Mr. Johnson, any further colloquy you would like me to undertake regarding this?
The only thing I would ask the court to potentially do in a moment is, I'm going to move to dismiss and read in counts 2 and 3. And I would ask the court to just briefly tell Mr. Patala what that means.
Mr. Cotton, as far as the plea colloquy that I've just undertaken, any further inquiry you'd like me to make?
No.
Based upon my discussions here on the record with the defendant, my review of his plea questionnaire and waiver rights form, my review of the facts in the criminal complaint, which he acknowledges form a sufficient basis for this plea. Based upon all those things, I'll find that his plea is freely, voluntarily, and intelligently made, and I will judge him guilty of count 1 of the amended information, second-degree reckless homicide. As to counts 2 and 3,
He moves to dismiss and read on those counts.
the objection?
No.
Mr. Patala, your attorney indicates he's not objecting to dismissing and reading in counts 2 and 3. You understand that dismissing and reading in are slightly different. First of all, did you speak with your attorney about that difference? You understand that by dismissing and reading in, it means that while you can't be sentenced on those counts, the court can consider those counts when passing sentence in this case. Do you understand that?
Yes, I understand.
Any further inquiry on that, Mr. Johnson?
No, I don't think there's going to be restitution.
Those two counts then, counts 2 and 3 of the amended information will be dismissed and read. I'm going to order a pre-sentence investigation report, and I'm going to schedule sentencing. I'm thinking that we're going to need at least a half a day for sentencing. I could be wrong.
No, that's fair.
That's fine.
And Judge, I don't want to jump you down too much here, but I'm just looking after the 4th of July with my schedule, just so the court's aware.
Okay. Just so everyone's aware, I can do quicker than that, but I'm happy to accommodate you. Any objection to that?
Can I just check?
Yeah,
Make
sure.
Do you guys have any suggestions on when sentencing?
I asked them, they're just going to Three Richmond answer, I think, for them. I think all along, they've always wanted this to be as soon as possible, but reasonable, I'm sure.
Makes sense.
Whenever you have time.
Mr. Cotton, I'm looking at an afternoon, and I'm looking at the afternoon of either July 14 or July 15.
14's good.
Mr. Johnson, any objection to the 14th?
No objection.
That's his anniversary. I'm not doing it that day.
Oh, that's a good.
He killed him that day.
That date, I mentioned that when I addressed things today, I told you it was July 14th of 2023.
15th, I'm in trial.
Yeah, I wouldn't like that.
I'll work on a different date. It looks like I have, I'm going to use an afternoon because I just think it's easier. Well, it's easier on my calendar. I can certainly try a morning, but I'm going to start with trying afternoons. And I'm looking at that next week, the week of the 21st. And surprisingly enough, I could do an afternoon on any of those days, other than I prefer not to do it on Thursday because I have a treatment court in the afternoon, although if it has to be Thursday, I'll work with it. But any of those afternoons, let's start with defense counsel.
I can do the 23rd in the afternoon. I can do the 24th in the afternoon. Those will be my 2 days available.
23rd, Mr. Johnson.
It is on Wednesday.
July 23rd.
It's a Wednesday. Okay.
So that's okay with the victim's day.
23rd, we'll start at 1:30, and we'll be moving on to the rest of the afternoon.
Yes, and then that won't be heard on the pre-sentence issue, and of course, there's the issue of remand as well.
Okay. So go ahead and your motion in the pre-sentence.
It's not really a motion, it's an objection to the pre-sentence having a recommendation of that. State's not objecting to that request. The basis for the request is the pre-sentence report obviously is designed to provide the court with information about Mr. Brutala, his background, his history, his characteristics. I think the problem with the recommendation in this case is there's absolutely nothing the pre-sentence author is going to glean from this case, spending a few hours with Mr. Brutala and doing an investigation or a background check into his history that justifies any particular recommendation. You're going to make the decision. Parties have worked hard to reach an agreement in this case that we think is we're not required to ask for the 5-year recommendation. Of course, the defense is free to argue, but the pre-sentence author, I don't think has any, they're not gonna go through the discovery, they're not gonna watch the videos, they're not gonna understand the dynamics of what took place. And you've seen enough pre-sentence reports as I have, that typically what happens is there's just a grid. They just look at the crime, there's a grid, and they plop in a number. And it's not tailored to the facts and the circumstances of the case. This is a 5-year recommendation on a second-degree reckless homicide is tailored by Mr. Johnson to the facts as he assesses the risk of the case and circumstances of it. So we don't object to a pre-sentence report. We think it's appropriate. You'll receive as much information about Mr. Padala as the author cares to investigate. We do object to a number being offered because obviously that's your call. We don't think the pre-sentence probation agent would have any specialized knowledge that would justify them making a recommendation in a unique case like this that has such strong self-defense contours to it. They're not going to look at it that way and consider it through that lens.
Mr. Johnson.
Part of the plea agreement, the state was going to ask for a PSI and we ordered it. And it was part of the agreement that the defense can ask for a PSI not to have a sentencing recommendation. And I am that the state would not object. He knows your decision.
Sure. Actually, I was recently asked the same question, and the attack was a little bit different. The attack was more on the lines of going, and I heard a little bit of this from Mr. Cotton, really going after the compass concept, using the risk assessment tool to make these recommendations to the court about sentencing. The case was slightly different than this one. Well, it was a lot different than this one. The charges were a little bit different. And I guess, first of all, in this motion, one of my responses was to indicate that I have full opportunity on a number of occasions to review State versus Loomis regarding the use of risk assessment tools, and I would kind of relate that to any kind of a grid or anything else that someone uses. In order for any of that to be usable by the court, I have to weigh all the relevant factors. I have to take a look at specific information to see whether or not the recommendations of the PSI make any sense in the context of what I know about a case. Each individual defendant is entitled to an individualized sentence from me, not some kind of canned sentence that everybody thinks is appropriate. For those reasons, I think the more information I have, the better. In that case, I said something that was really attacked, if you will, and that is, I find a recommendation from someone trained in criminal justice to be useful. Maybe I don't follow it. And the attack essentially was, criminal justice, what does that mean? They don't have any real world experience, and I get it. But nonetheless, I find those recommendations to be interesting, potentially useful, potentially useless, and I will make sure that Mr. Potala receives an individualized sentence from me, as is my obligation, but I'm going to get as much information that I can, including a recommendation of the PSI, so that motion is going to be denied.
Regarding bond, we, as of today, before the plea, he was presumed innocent. If we had a trial, we'd have to try and prove it. He's now lost that presumption of innocence. We convicted of a homicide charge, a second-degree reckless homicide. So I'm going to ask the court to revoke bond and ask that Mr. Potala be held until sentencing without bond.
That's fine. That's fine.
I'm ordering bond revoked, and we'll be back here for sentencing then in July. Anything else?
Oh, one more thing. It's important to the family too, I believe. I want to put this on the record. The family wanted to have CPC, the victim's phone returned. As part of this investigation, there was a phone extraction. We got all the information off the phone. The defense has it as part of discovery. I think his family wants CPC's phone back. I'm okay with that, and I told Mr. Cotton, if he puts on the record today, that the defense is okay with that as well, then I'm going to return it. I wanted that on the record.
We have the same request to have our client's phone returned. We don't object to the state's request, I'm assuming you don't have an objection to ours. There's pictures on it just like that.
That wasn't part of what you were recommending.
No, I don't know if I'm going to agree to the defendant's phone. for the best.
Okay, well, here's what I'm gonna do. Because I don't think this, because I'm in the middle, I'm not gonna tolerate, if you don't agree, then I won't. And I'm not gonna work with that. So you've agreed that CPC's phone is gonna get returned, and I'm gonna work with it. But I'm not gonna ignore what Mr. Cotton wants. Mr. Johnson, I need you to get back to Mr. Cotton within 10 days. 10 business days. Object? I don't object. If you don't object, please notify me by copying in the letter, copying in, saying, go ahead and release the judge, and I'll draft an order. If you do object, Mr. Cotton, I'll set up a hearing and we'll address that. Okay?
Great.
Anything else?
No, thank you.
Anything else? No. All right. We're in recess.
Yeah.